Well, there's always a risk, but typically when you're building a commercial product, you rely on suppliers that have reputations and agreements, and if you're really concerned, contracts that you can fall back on.
So it would be, I think, the role of the manufacturer, also of your supplier, to actually make sure that there are no IPR infringements there. As user, okay, you're using, but this would be
question.
Yes.
There's some context to this stuff we're showing here. It's typical lab application, so CERN wouldn't design this unless they wanted it for their own use.
Yes.
And so then they're faced with the problem of getting production, and their normal philosophy is to go out to industry production. So in a sense, it's kind of a closed situation. They're licensing it because they don't want to just give it to somebody who's not competent and wants some control of the product. So it's like kind of a little closed loop. All the labs are doing this on some level.
Not all labs. I think there is probably there's growing interest in going there, but it's not necessarily the default.
Well, I can tell you other labs are doing this. I mean,
Yes.
Daisy is doing this big time.
Yes, and this is, I mean, in many ways, Daisy is collaborating concerning some of those. Yes.
Is there a service from any foundation or organization that does a patent search on some of these open source designs, or has something like that? I think Eclipse Foundation has some service like that for the membership from the industry. But you know, on the experience you may have with the CERN license, have you heard or come across any company offering patent searching hardware for before going to the license process?
No, I haven't heard of.
Can I ask you a question if you know? How many different patent agencies are there across the world?
What do you mean patent agencies?
where you can license your patents, where you can submit your patents, and then
Like patent offices,
Yes.
as many as there are countries, basically, at least.
So you can see the problem in asking a law firm to go out and ask to
you can
hire
hire
for all IPR.
You can hire people to do it. It's just very expensive, and there's never a guarantee. So all you're doing is limiting your liability somewhat.
Patent attorneys can do some
Yeah.
due diligence for you. Of course, it's okay. So that's it for me. Thank you.
Yeah, one of the things is, depending on the scenario, is if your alternative is to develop it yourself versus use the open source hardware design, you probably have very similar risk profiles, because the risk out there is there's a reef out there. So whether you're in a rental boat or your own boat, if you hit the reef, you still sink.
I was going to comment that 5, maybe you could reword it, what is helped with an LLP, so it would be LP.
Well, corollary to all of that, though, and I'm not trying to, I'm a big fan of open source, I use it personally, but is, and I don't necessarily agree with this, but I kind of believe it as being the state of the nation, if you will, of the world. In the commercial world, the saying is your contracts, your IPR, whatever, is only as good as the lawyers you can afford. So all of the licensing agreements and their various perturbations, they don't mean anything to the common person trying to build something or develop something unless they can afford protection, right? I mean, the recent case, the case of the fellow that went to court for 25 years to fight for the IPR on a microcomputer design. That took a lot of dedication and a lot of money.
Yeah, I mean, there's fundamentally issues like, you know, what you can get in terms of legal protection negotiation, what protection you can get on intellectual property, but what you can afford to do in terms of enforcing. There are multiple things. I spend a lot of time at Nortel, and that's where I really cut my teeth around open source software. And I remember very early on doing a presentation where I said, neat this interesting thing you're working on, but it's premised on a far too altruistic view of human nature than I, as a lawyer, am involved to embrace. The second thing I said is very easy as a lawyer to see open source software as the worst of all worlds, because you end up with a product that you didn't control the development of, but you have none of the protections that you would get in terms of a commercial arrangement. But I think over time, I've just learned that there's proprietary software, there's the stuff you write yourself, and then there's open source software, and they all have their place, they all have their characteristics. It's also equal to argue that open source software is the best of all worlds, because you get it without the development costs and without all of the nonsense that is often around the negotiation of proprietary software licenses. But I mean, this is a great discussion. So in terms of help, I've been kind of playing around with this with Alfredo for a while, and I think help, as I'm calling the Humanitarian Engineering Licensing Protocol, because as we've seen, for example, the Discern open hardware license, specifically covers hardware, not software. The discussion that Andrew has had, in terms of there's a range of options around software licensing. Some of the products that projects Alfredo mentioned are software, and we can choose one of the licenses. Some are going to be hardware, and maybe the CERN open hardware license is a good choice. Some are going to be systems where you're going to have software and hardware, so you have to address all those things. So in terms of, I guess, my big picture recommendation, and dealing with Alfredo and then talking to the IEEE lawyer several weeks ago, is just I'm encouraging or recommending that IEEE adopt really a licensing protocol for its humanitarian engineering kind of open source projects. And I think it should cover those IEEE initiatives that it's running, and we'll run through some of the characteristics. And it should also cover those situations where is the IEEE interested in being a co-sponsor on a project, or potentially steering its members towards this is a project you might be interested in getting involved with. So when it comes to the IEEE sponsored open source projects, I think you need to cover these range of different things, as I mentioned earlier. For example, this is a potential approach. The Eclipse public license, I had to use a diskette because it was just too old and funky.
Thanks, man.
Yeah, just nostalgic. I came across, remember the Wang word processing discs that are about this big? Yeah. Okay, the open, I couldn't find the headlamp anywhere, so I had to use a flashlight. So perhaps the open hardware license would be a good fit for that. And then systems, I'm not sure exactly. This is, I think, some type of Cisco switch. I was looking for essentially open source clip art, so it's pretty primitive. But maybe in that situation you do a combination of the Eclipse public license with software component and the open hardware license. And then with respect to those projects that IEEE would want to team with other organizations or encourage its members to get involved with, I think it's a matter of sitting through, okay, what are the qualifying conditions? What do we expect of either co-sponsors or projects in this space? And as Miriam had touched on, and I think Andrew touched on it. If not, there are open source. The Open Source Institute has certain rules about OSI compliant open source licenses. The work with different open hardware associations. What are the rules? What are the statements of principles? What are going to be the criteria the IEEE decides whether it's willing to team on a project or support another project? So I think that's when I talk about help, it's just a matter of stepping up, looking at creating really a toolbox of options that are available, supported by the IEEE for projects that are coming out of their humanitarian engineering initiative. And then the next part is, as part of really help, is okay, well, what are some of the things as we develop that toolbox for the IEEE? What are the things you need or should be thinking about? And I'm going to suggest Miriam and Andrew come up, and then we're just going to step through some of the slides, and we'll talk to the different elements of governance. Because as you recall, we had this slide before, really the pieces of the open source project puzzle. And what we'll do is we'll just kind of talk about some of the topics. I realize I think we're recording the session, so I suppose this doesn't look very movable. try? People have to come up. So the first one is really it's a big picture issue of governance, and I know Andy, you already talked about your experience in terms of, but maybe a little bit more on this open source software project in the box and what some of the advantages.
Sure. I'll chat a little bit, and this part of the session we kind of wanted to be interactive. So if you have any questions, shout, and we'll digress if we need to. So what's interesting is that in the last number of years, 5-6 years, GitHub, a very famous set of infrastructure, they basically made Git code repositories, bug tracking systems, little web space, these kind of things, super easy for people to create an account, post some code, and in some cases, build a community. What's interesting is that you notice that's just infrastructure, right? It doesn't talk about how do you get involved in those communities, how do you make a decision if there's a conflict between different interested parties, how do you resolve that? It doesn't talk about licensing model, it doesn't talk about intellectual property management. So there's a number of things that you don't get from GitHub that you get, if you actually have a formal governance model. And of course, if you come to a software foundation like the ones I mentioned, the Eclipse Foundation, Apache Software Foundation, Linux Foundation. And there's others as well, other ones too. So really, the governance, I often use a metaphor that if you think of a sports league, people can play sport, whether it's football, soccer, whatever you want to call it, hockey, baseball, they can play that with very little formality. They can just go out to the field, take the ball, take the stick, and play a game. What's interesting is that they don't even necessarily have to agree fully on the rules. That often they'll have a discussion and decide what the rules are, where the boundary lines, whether you're allowed to pick the ball up with their hands or not. And so as you progress from a very informal sort of pickup game where the rules are very fluid, and you start wanting to engage industry and governments and larger organizations, it's very important to capture those rules. So there was a great question about how do you engage industry and get sort of a clear understanding of what the rules of engagement are, and especially to balance that out, because some companies are very large and have lots of money and maybe lots of people. And you might want to have small and medium-sized companies and individuals engage in that. How do you keep that from being overwhelmed? And so the governance model is a key and essential part of that. So I just want to pause for a second. Does anybody have any questions about that or thoughts or anything you want to share? Okay. I guess we'll move on to the next topic then.
Next is really just discussing, kind of the founder, and I think there's been a few times we've talked about the complexity around, legal agreements and kind of, obviously working with a bunch of agreements. And I think Andrew's example is as you start to scale the number of the complexity increases. But the one very interesting about open source projects, as Andrew's slide points out, is you kind of centralize, and in many cases you simplify the legal aspects of it, because back to the question about engaging business, is you as a project, once you kind of work through these criteria, you've established what your project objectives are, you've established what the ground rules are. It's not a matter of, commercial interests show up, if you've got a very interesting project, this is not a matter of them saying, oh, yeah, we're interested in getting involved, we're going to send you our 400-page agreement if you want to review it. It's, if you want in, these are the rules. I mean, often a good foundation organization will evolve over time, because sometimes, for example, and that's certainly one of the challenges of setting up an open source foundation, is the documents that set it up, you usually capture a particular vision, and things change over time. So it's that ability, that willingness to adjust. But for the most part, it's actually a lot easier for the smaller individuals to engage with an open source project, because it levels really the playing field, because you put everyone on the same paper. And I negotiate a lot of agreements, and I'd love to get very, very extreme positions, unilateral positions being sent to me, because what I'd love to do is just make them mutual and send them back. And then you hear from the company saying, I couldn't possibly live with that provision, which makes you wonder, well, why did you ask me to live with that provision? So I think that that's a way of kind of balancing the playing field. In terms of first piece of the puzzle is the founder, and maybe It's typically either an individual, organization, or company. And what does the founder typically bring? It's either a founder or a group of people. It's really the technical vision and an assessment or belief in terms of who the community is. Because there's going to be, typically a technical thing, and a belief that there's an opportunity for it. And obviously, the success of an open source project is going to be largely dependent upon technical merit and acceptance by both the target user community and the contributor agreement. I think the discussion we can have around governance is the governance are all the things that help it's another, it's kind of like the third leg on the stool. It's something that supports those other things. Governance will never make an open source project successful, but poor governance can make it unsuccessful. So I think that's any questions on this? I mean, the founder might seem fundamentally easy, but some of the discussions we've had with Alfredo is, okay, given the structure of the IEEE and one of these projects, who's the entity and who's the owner and how do we structure? So. Seed contribution, and the discussion around seed contribution is, as I said, there's usually some form of technology that's being brought in the first instance that is going to be the basis for the project, and and depending on the nature of the technology, one of the limitations that may come in is really, well, what's the intellectual property cleanliness, i.e. pedigree of it? And that touches two ways. One is, does the founder or the entity contributing for example, this code, do they actually have the rights in it necessary to make that contribution? And then there's the broader issue of, are there third-party rights which read upon that seed contribution? I think both are important things. I mean, I've worked enough in industry that I believe that the technology, any sufficiently complex form of technology is going to be infringing someone's rights somewhere, and it just becomes a question at what point are you going to run into that as an assertion. And some of my blog posts have said that, on the other hand, the beauty of the open source movement, whether it's hardware or software, is its agility and its ability to adjust. And I have a good friend who has done a lot of patent enforcement, and we've talked about the open source, and he says the one thing about the open source movement is its ability to change and adjust. And in one sense, while patents may be asserted against open source, it's kind of it's a hard target because it's a quickly moving one. Alfredo?
Yes, so if I understand the seed contribution, what you're saying is that yes, there has to be an assessment on the intellectual property cleanliness, but for hardware, I know for software that that is you can do a text search in Google and then you see if you can, or some other sort of test that you can do on a text, but on hardware, claiming ownership of a physical design or something, it goes beyond just doing a text search. It has to, it's about the actual idea, what it brings, what is the capability, functionality, layout, physical dimensions, and a lot of other aspects. What are the best practices and the differences, and what are the difficulties that has to be addressed? Like what would be like a basic checklist or sanity check that we need to do managing such a project?
Well, I'll maybe ask Miriam if you want to speak to this, but I think fundamentally there's a number of different layers to the issue. One is if I'm showing up bringing this package of things to the table, for example, let's say I want to offer it as a seed contribution for a project at IEEE, at the very least, I can't have taken those things, stolen them from the backyard of my neighbor and put them in a box and brought them to the IEEE. So there's fundamentally an issue that these things are mine, i.e. I can establish like a chain of title and we'll come to the agreement. And so a lot of, if you're acquiring a company, a lot of due diligence is, do they actually have rights? Have they, have the people who worked on this project actually signed the necessary agreements so that the rights flow in? The second side of it, as we're talking about, is okay, are there rights outside of that? And when it comes to hardware, I mean, hardware is subject to different forms of protection. But can you talk to?
Yes. Well, all of that is true, and I would say even when you look internally, so the first thing is, yes, what you're bringing to the project, is this yours? This is the first thing. The second thing is also the type of relationship. I mean, working at CERN, big organization, lots of collaboration with different people. Well, the first thing to know is also what is your relationship between the organization and the individual, and see exactly a lot of ownership, due diligence has to go on already from the very, very start. And then the second thing that you have to do, as Tom said, is externally. So there is a very minimum research you need to do, and often in academia, people will look at the literature, but a good way to also do the research is simply go into the patent databases, and we're encouraging more and more the engineers at CERN to go there, and very often you will have information as to what is the state of the art and how to design the project and all that.
It's a question for you because you used to work there, as I did. Nortel had a policy, you did not read patents if you were a design engineer. I assume it's because of denial of plausibility, or plausible denial.
Well, I mean, one of the concerns has always been in the U.S. is doctrine of willful infringement. That as soon as that you are infringing, then your damages, so the risk of treble damages. So that's one of the concerns. The second concern is like, can you, I mean, the interpretation